For more background on this case, what it meant for the citizens of Jackson, and who Brenda K. Monroe-Moses is, please watch the story of Jackson Central Mary. Most of this video is a verbal reading of the actual court document. Please skip to the end if you want to hear the basic breakdown of the document. All right, so welcome. Today I'm going to be reading and interpreting for you Monroe and the United States of America versus the Jackson-Madison County School System Board of Education. Now, I'm going to be interpreting this as a citizen. And this document is published for the public, meant to be interpreted for citizens to understand. So, without further ado, order granting motion for declaration of full unitary status and dismissal. Before the court is the joint motion of plaintiffs Brenda K. Monroe. The defendant is Jackson-Madison County School System Board of Education. For a declaration that Jackson-Madison County School System has achieved full unitary status and dismissal. The court has found that the Jackson-Madison County School System has achieved unitary status in the areas of facilities, faculty, staff, transportation, and extracurricular activities. The only issues remaining in the case are whether Jackson-Madison County School System has achieved unitary status in the area of student assignment and whether it is entitled to a declaration of full unitary status. After consideration of the record before the court and community member statements at a public hearing on August 23, 2010, the court declares that Jackson-Madison County Schools has achieved full unitary status to the extent practicable. Therefore, the court grants the joint motion and dismisses this case as to all parties and claims. Factual background. This case began in January 1963 when the parents of African American school children sued the Jackson, Tennessee and Madison County, Tennessee school districts and their superintendents in federal court seeking an injunction ordering the defendants to cease operating racially segregated public schools. At that time, despite Brown versus the Board of Education, Tennessee law required pupils to attend the racially segregated schools. The sole accommodation of Brown was the authority granted school boards to approve assignment and transfer requests. So a number of white children were enrolled in African American schools, and Jackson's school board had granted the applicants of only 7 African American children to enroll in white schools during 1961 and 1962. On June 19, 1963, this court granted plaintiffs' motion for summary judgment and ordered the defendants to file plans to desegregate and eliminate racial discrimination in the Jackson and Madison County school districts. Since then, this court has retained jurisdiction over the case and issued numerous orders. In 1989, this court approved the consolidation and unification of the school systems in Jackson and Madison County into one school system, the Jackson-Madison County School System. In 1990, the parties reached an agreement memorialized in a consent judgment entered by this court. The consent judgment required for the board to develop a plan to recruit minority applicants for certificated positions, encourage minority students to participate in all academic programs, follow a majority to minority transfer policy, permitting students attending schools in which their race was in the majority to choose to attend schools in which their race was in the minority, if space were available. Establish voluntary magnet schools designed to attract substantial numbers of minority and non-minority students, with advertisements to make parents aware of Jackson-Madison County Schools' magnet programs. Adjust school zone lines beginning with the 1992 to 1993 school year. Make capital improvements to existing schools and construct new schools. After the consent judgment, the number of racially identifiable schools declined. Although 13 of 16 elementary schools in Jackson-Madison County were racially identifiable during the 1989 to 1990 school year, with enrollments in 11 schools consisting of 80% or more of students of one race. Only 3 of 14 elementary schools were racially identifiable during the 1992 to 1993 school year. From the 1992 to 1993 to the 2002 to 2003 school year, none of Jackson-Madison County high schools were racially identifiable. Between the 1992 to 1993 and 1998 to 1999 school years, none of Jackson-Madison County's middle schools were racially identifiable. In 2000, the parties entered into an agreement approved by this court to update the 1990 consent judgment and adopt a long-range plan to identify steps for promoting the desegregation of Jackson-Madison County school system that would ultimately lead to a declaration of unitary status. Note, the 1990 consent judgment defined a school as non-racially identifiable if the ratio of minority students to the school's enrollment was within plus or minus 15% of the ratio of minority students to district-wide enrollment. Jackson-Madison County School System agreed to construct new schools, hire facility consultants to make recommendations for improving schools, advise parents and the public of the long-range plan's educational components and pupil assignment options to encourage desegregated schools by voluntary means. Develop a plan to encourage minority students to participate in all programs and activities. Submit annual reports to Parties Council detailing its efforts to comply with the agreement. Create a biracial committee with annual alternating racial majorities to act as an advisory committee concerning the desegregation process. And devise a dispute resolution process outside of the court to mediate disputes. The parties agreed that if Jackson-Madison County School System fully implemented these steps, it would be positioned to obtain unitary status in all areas. The parties agree that Jackson-Madison County school systems have complied in good faith with the 1990 consent judgment and the 2000 agreement. Nevertheless, the number of non-racially identifiable schools has decreased since the 2000 agreement. During the 2001 to 2002 school year, 8 of 14 elementary schools were non-racially identifiable, but only 3 of 14 were in 2009 to 2010. Note, the 2000 agreement defined a non-racially identifiable school as a school in which the percentage of black students is 15% of the district-wide black student enrollment percentage at that grade level. During the same period, the number of non-racially identifiable high schools decreased from 3 of 3 to 2 of 5. The opposite trend occurred in middle schools during the 2001 to 2002 school year. 2 middle schools were racially identifiable, but only 1 was in 2009 to 2010. Since the court assumed jurisdiction in 1963, the racial composition of Jackson-Madison County school systems has changed. For instance, during the 1968 to 1969 school year, the Jackson City School District was 57% white and the Madison County School District was 61% white. But the merged Jackson-Madison County school system now has 13,716 students and is 59% African American. The tentative racial composition of schools during the 2010 to 2011 school year shows that of the 27 schools in Jackson-Madison County school system, 3 have student enrollments of over 90% from one race, and 6 have student enrollments of over 80% from one race. On July 9, 2009, the board voted to pursue a declaration of unitary status. At the time, the board had 5 African American members, including the chairman, and 4 white members. On August 23, 2010, the court held a hearing in Jackson, Tennessee, to give the public an opportunity to address the parties' proposed settlement, which would declare that Jackson-Madison County school system has achieved unitary status. 6 people spoke at the hearing, including 2 of the case's original plaintiffs. Several speakers said that the problems remain in Jackson-Madison County school systems. Problems identified include excessive busing of students, discrimination in hiring disabled people as faculty and staff, lack of trust between community members of different races, underperforming schools, lack of commitment to children, and tension in the community. Frank Walker, one of the original plaintiffs, spoke in opposition to the proposed settlement. He stated that class counsel has not adequately consulted with the plaintiffs. Jackson-Madison County school system lacks an adequate number of minority teachers, and some schools have severe condition problems. Brenda K. Monroe-Moses, the named plaintiff, also spoke in opposition to the proposed settlement. She stated that class counsel has not adequately represented her interests. Jackson-Madison County schools teachers' hiring practices have led to a return of segregation, and Jackson-Madison County school system needs a new performing arts high school in downtown Jackson. At the hearing, the court announced that it would consider any additional information submitted by counsel no later than August 30th, 2010. No information has been filed since the hearing. Analysis. To hold that a unitary, non-racial school system exists and allow resumption of local control, the court must find that 6 features of the school system have been freed from racial discrimination. 1. Student assignment. 2. Faculty assignment. 3. Staff assignment. 4. Facilities and resources. 5. Transportation. And 6. Extracurricular activities. On August 5, 2009, the court declared that all areas except student assignment had achieved unitary status. The only issues remaining are whether Jackson-Madison County school system has achieved unitary status in the area of student assignment and whether it is entitled to a declaration of unitary status. Although the term unitary is not a precise concept, a unitary school system is essentially one that has been brought into compliance with the Constitution. To be brought into compliance, a school district, once segregated by law, must take all steps necessary to eliminate the vestiges of the unconstitutional de jure system. This is required in order to ensure that the principal wrong of the de jure system, the injuries and stigma inflicted upon the race disfavored by the violation, is no longer present. This was the rationale and the objective of Brown 1 and Brown 2. The goal of federal courts' involvement in school desegregation cases is to ensure that the transition to a unitary, non-racial system of public education to remedy the constitutional wrong. School desegregation cases are not unique. As the Supreme Court has stated, a school desegregation case does not differ fundamentally from other cases involving the framing of equitable remedies to repair the denial of a constitutional right. The task is to correct, by a balancing of the individual and collective interests, the condition that offends the Constitution. Once the school district has achieved that task, federal court supervision of school systems must end at the earliest practicable date. The Supreme Court has emphasized that federal court supervision is a temporary exception to the general rule of local authorities' control of school districts. Noting that although federal judicial supervision of local school systems may last decades, the end remains returning school districts to local authorities' control once they comply with the Constitution. From the very first, federal supervision of local school systems was intended as a temporary measure to remedy past discrimination. Local control promotes accountability to citizens, the political process, and the courts in the ordinary course. It enables citizens to participate in decision-making and facilitates innovation in educational programs to fit local needs. Thus, desegregation decrees are not intended to operate in perpetuity. The ultimate inquiry in determining whether a school district is entitled to a declaration of unitary status is whether the constitutional violator has complied in good faith with the desegregation decree since it was entered, and whether the vestiges of past discrimination have been eliminated to the extent practicable. A vestige of de jure segregation is a current or latent racial imbalance that is traceable in a proximate way to the prior violation of the 14th Amendment. The more time has passed since the de jure violation, the more demographic changes intervene and less likely it is that a school district's current racial imbalance is a vestige of past discrimination. In deciding whether to declare unitary status, courts must consider three factors. 1. Whether there has been full and satisfactory compliance with the decree in those aspects of the system where supervision is to be withdrawn. 2. Whether retention of judicial control is necessary or practicable to achieve compliance with the decree in other facets of the school system, and whether the school district has demonstrated to the public and to the parents and students of the once disfavored race its good faith commitment to the whole of the court's decree and to those provisions of the law and the Constitution that were the predicate for judicial intervention in the first instance. When considering these factors, a court should give particular attention to the school system's record of compliance. In this case, Jackson-Madison County School Systems has complied in good faith with the desegregation decree and eliminated the vestiges of past discrimination to the extent practicable. The court has already found that Jackson-Madison County School Systems has complied with the desegregation decree, demonstrated a good faith effort to desegregate, and eliminated the vestiges of past de jure discrimination in all areas other than student assignment to the extent practicable. A careful examination of the record demonstrates that Jackson-Madison County School System has similarly proven its good faith and eliminated vestiges of past discrimination in the area of student assignment. The court finds that there has been full and satisfactory compliance with the decree in those aspects of the system where supervision is to be withdrawn. Although the number of racially identifiable schools has increased in recent years, the parties agree that Jackson-Madison County School System has complied in good faith with two agreements designed to promote desegregation: the 1990 consent judgment and the 2000 agreement. To promote desegregation, Jackson-Madison County School Systems took numerous steps to encourage integrated schools. Between the consent judgment in 1990 and the agreement in 2000, Jackson-Madison County School System, in good faith, attempted to establish voluntary magnet schools, develop a plan to recruit minority applicants for certificated positions, change school zone lines, make capital improvements to existing schools, and construct new schools. Although proving causation is difficult, the court notes that, after the 1990 consent judgment, the number of racially identifiable schools remained low. At the very least, this demonstrates Jackson-Madison County School System's good faith attempt to eliminate the legacy of dual school systems, one for African Americans and one for whites. Pursuant to the 2000 agreement, Jackson-Madison County School System made significant efforts to construct new schools, hire facility consultants to make recommendations for improving schools, advise parents and the public of the long-range plan's educational components and pupil assignment options to encourage desegregated schools by voluntary means, develop a plan to encourage minority students to participate in all programs and activities, submit annual reports to Parties Council detailing its efforts to comply with the agreement, create a biracial committee with annual alternating racial majorities to act as an advisory committee concerning the desegregation process, and devise a dispute resolution process outside of the court to mediate disputes. The parties agree that Jackson-Madison County School System has complied in good faith with its obligations under the 2000 agreement. Despite Jackson-Madison County System's good faith efforts, the number of non-racially identifiable schools has decreased. The number of non-racially identifiable elementary schools declined from 8 of 14 in the 2001 to 2002 school year to 3 of 14 in the 2009 to 2010. And the number of non-racially identifiable high schools declined from 3 of 3 to 2 of 5. Nevertheless, not all facts suggest increasing segregation. During the same period, the number of racially identifiable middle schools fell from 2 to 1. The most important factor in deciding whether Jackson-Madison County School System has fulfilled its constitutional obligations is the absence of any evidence that the current racial imbalance is due to racial discrimination. That matters because the Constitution is not violated by racial imbalance in the schools without more. As evidenced by Jackson-Madison County School System's efforts to integrate its schools, the something more is missing here. Thus, the racial imbalance does not have constitutional implications. That there was racial imbalance in students' attendance zones was not tantamount to a showing that the school district was in non-compliance with the decree or with its duties under the law. Racial balance is not to be achieved for its own sake. It is to be pursued when racial imbalance has been caused by a constitutional violation. Once the racial imbalance due to the de jure violation has been remedied, the school district is under no duty to remedy imbalance that is caused by demographic factors. 47 years have passed since this court assumed jurisdiction in this case. During that time, much has changed. The racial composition of Jackson-Madison County School System has gone from roughly 60% white to 59% African American. The city and county school systems have merged, and the board voting to pursue a declaration of unitary status was majority African American. In the course of these changes, the segregation justifying the court's involvement in this case has become more and more remote, decreasing the likelihood that any racial imbalance today is a vestige of past discrimination. Although the recent increase in racially identifiable schools is disappointing, Jackson-Madison County school systems is comparatively more integrated by many measures than other school systems entitled to a declaration of unitary status. For example, the United States Court of Appeals for the Fifth Circuit has affirmed a district court's declaration of unitary status where 57 of 226 schools had enrollments in which 90% or more of the students were from one race. By contrast, only 3 of Jackson-Madison County School System's 27 schools have enrollments in which 90% or more of the students are from one race. In Freeman, the Supreme Court affirmed a finding of unitary status in a school district where 47% of the students were African American. 50% of African American students attended schools that were over 90% African American. 27% of white students attended schools that were over 90% white. 5 of 22 high schools were over 90% African American. 5 of 22 high schools were over 80% white. 18 of 74 elementary schools were over 90% African American, and 10 of 74 elementary schools were over 90% white. In comparison, Jackson-Madison County School System has far more racial balance. Of Jackson-Madison County School System's 27 schools, only 3 have student bodies over 90% African American. No school is over 90% white, and only 6 schools have over 80% of students from one race. This is not to suggest that numbers tell the whole story. The Supreme Court has emphasized that they do not. The existence of some small number of one race or virtually one race schools within a district is not in and of itself the mark of a system that still practices segregation by law. Numbers matter only to the extent that they reflect segregation's legacy. Constructing a unitary school system does not require a racial balance in all of the schools. What is required is that every reasonable effort be made to eradicate segregation and its insidious residue. If school authorities exclude no pupil of any racial minority from any school, directly or indirectly on account of race, the objective of federal courts in school desegregation cases is satisfied. The current racial imbalance in Jackson-Madison County school system is the product of demographic changes and private schooling choices that the school district has no duty to remedy and that fall outside the court's equitable powers to address. Jackson-Madison County school system has made significant efforts to overcome past discrimination. Those efforts convinced the court that Jackson-Madison County school system has complied in good faith with the original desegregation decree and eliminated the vestiges of past discrimination to the extent practicable in the area of student assignment. Further judicial supervision is unnecessary. Retention of judicial control is not necessary or practicable to achieve compliance with the desegregation decree and any other facet of the school system. Aside from Jackson-Madison County School System's good faith compliance with the 1990 consent judgment and the 2000 agreement, a majority of African American board voted to pursue a declaration of unitary status. Minority presence in the power structure is a factor that might be expected to help prevent any regression to a dual system once the court's presence is withdrawn. Therefore, the court finds that the leadership of Jackson-Madison County School System is unlikely to return to the school district to its former ways. Jackson-Madison County School System has demonstrated to the public and to the parents and students of the once disfavored race its good faith commitment to the whole of the court's decree and to those provisions of the law and the Constitution that were the predicate for judicial intervention in the first instance. The parties agree that Jackson-Madison County School System has complied in good faith with the 1990 consent judgment and the 2000 agreement, both of which the court approved and made enforceable as court orders. The joint nature of the motion to declare unitary status must receive considerable weight given the public policy favoring settlement of desegregation cases where, as here, the motion is reasonable, filed in good faith, and demonstrates that the constitutional mandate requiring desegregation has been satisfied. Several members of the community have objected to ending court supervision. If the concerns stated at the August 23, 2010 hearing are correct, substantial work remains to be done in improving Jackson-Madison County school systems and building ties to strengthen the community. Nevertheless, most of the concerns expressed, such as underperforming schools, condition problems in school facilities, and tension in the community, cannot provide legal justification for further judicial supervision in this case. The legal justification for displacement of local authority by an injunctive decree in a school desegregation case is a violation of the Constitution by the local authorities. The court has addressed the issues raised that could provide legal justification for further court supervision, such as the inadequate number of minority teachers in its prior order declaring unitary status in the areas of faculty and staff. Because no additional evidence before the court addresses discrimination in faculty hiring, the court need not revisit its prior order. Community perceptions are relevant to whether Jackson-Madison County School System has demonstrated its good faith commitment to ending discrimination. Here, those perceptions favor declaring unitary status and dismissing the case. The concerns stated at the August 23, 2010 hearing, such as underperforming schools, lack of commitment to children, condition problems at schools, and the need for a new performing arts high school in downtown Jackson, are precisely the kinds of concerns best addressed through local control and political accountability. The need to promote accountability is an additional reason to end judicial supervision in this case. Because each of these three factors, this court must consider favors declaring unitary status. The court finds that Jackson-Madison County School System is entitled to a declaration of unitary status. All evidence before the court indicates that Jackson-Madison County School System has complied in good faith with the desegregation decree since it was entered, and the vestiges of past discrimination have been eliminated to the extent practicable. After 2 generations, it is time to return control of the Jackson-Madison County School System to the people of Madison County and their elected representatives. Conclusion. For the foregoing reasons, the court declares that the Jackson-Madison County School System has achieved full unitary status. Therefore, the court grants the joint motion and dismisses this case with prejudice as to all parties and claims, so ordered this 24th day of September, 2010. Samuel H. Mays, Jr., United States District Judge. Okay, so this document is pretty cut and dry. There's only a few things I'm going to address about it. So, the official case began in 1963. That's when this document is filed. However, the fundamentals for this case began in 1960. Similarly, the 1990 agreement was first discussed in 1988. I'm working hard to collect more information on the context of this case, as I've found much of race relations from these time periods was purposely never recorded. So, let's start with the big elephant. The changing wording of the statistics. So at the beginning of this court document, it starts to refer to schools as racially identifiable. Somewhere halfway through the document, around the time that the school is presenting their defense, it refers to the schools as non-racially identifiable. Edit here, I also want to mention that during the 2000 agreement, the definition of racially identifiable did change, and that is noted in the first notation as well as the second notation. Explains the change in definition of what is racially identifiable and what is non-racially identifiable. This really wouldn't make a difference unless you're just scrolling through the document and happen to see that the numbers look about the same from 20 years ago. So let's actually look at that. Okay, so it says in 1989 to 1990 school year, 3 of 16 elementary schools were racially identifiable. So then in the 1992 to 1993 school year, 3 of 14 elementary schools were racially identifiable. The document explains this as like a drop in racially identifiable schools, but even the numbers say that all they did was close 2 schools. And they integrated them. But as we may see in some of these other historical videos, integration was not necessarily the absolute solution to these problems. So then let's look at where they change the wording of the statistics. It goes on to say, during the 2001 to 2002 school years, 8 of 14 elementary schools were non-racially identifiable, but only 3 of 14 were non-racially identifiable in 2009 to 2010. So let's actually reword that so that it matches our statistics from the first section. That means in 2001 to 2010, 6 of 14 elementary schools were racially identifiable. In 2009 to 2010, when this court case was dropped, 11 of 14 schools were racially identifiable. So during the 1989 to 1990 school year, the year of the first amendment of the agreement, 3 of 16 elementary schools were racially identifiable. So then in 2009 to 2010, the time at which the agreement was dropped completely, 11 of 14 schools were racially identifiable. And what they also seem to leave out, but the numbers tell and the evidence tells, those numbers dropped because they were busy closing schools that entire time. In spite of the document requiring them to open new schools, they spent that time and continue to close schools. So I think those things are kind of telling for themselves. It goes on to say, too, that, the school system's defense is that it met all the requirements. Seems to just be a complete restatement of those requirements. Now, that just might be for the convenience of the court document, but, it's entirely possible that they just handed the judge a piece of paper that was literally a printout of the first agreement they received, and they said, look, we did all this stuff. So then one last thing I'll say is that the 2 plaintiffs from the original case continue today, 10 years after this case was dropped, to fight for the school's right to exist, as well as their own right to exist in the community. It says here, too, a majority African-American school board did vote to allow control to return to the county. In their view, this meant that control of the schools, their funding, and their maintenance would be in their hands at that point. And if you're wondering what things look like since that 2010 decision, please see my video on the future of Jackson-Madison County school systems. Thanks for watching.